as the title of that was given to my presentation suggests, the Privacy Shield saga is not only about the transatlantic relationship, it's not only about EU-US data flows, but its relevance goes beyond that, as it will be the first adequacy decision that will be adopted by the Commission after the Schrems judgment. And in the meantime, by the way, key elements of the Schrems judgment have been codified, in a certain sense, have been incorporated in the GDPR, in particular in Article 35 of the GDPR. So for a number of elements, the privacy shield is a sui generis, if you want, adequacy decision, but it is also an adequacy decision of the post-Schrems era, if you want. So the question is not only what will happen to existing adequacy decisions. I think an answer is clearly provided for in the regulation itself, but what will be the prospects of possible other or future adequacy decision. But coming back to the privacy shield we published in February, draft privacy shield we published in February is a very different and significantly, we believe, strengthened transatlantic data framework compared to the safe harbor that was invalidated by the court. We believe it responds both to the 13 recommendations, because our work on transatlantic data flows had started well before the Schrems judgment, so we had issued in November 2013 13 recommendations. So we believe that this new framework responds both to the 13 recommendations and to the criteria set forth in the Schrems ruling. Since then, since February, we have further improved and clarified the arrangement, responding to comments and recommendations from the Article 29 Working Party, the DAPS, the European Parliament, member states, the complexity of the EU, many comments, but as I'm sure you know, these comments all stress the significant improvements introduced in the privacy shield compared to the former safe harbor, but also raised some questions and concerns. We have worked with the US in the last few weeks, I would say also including the last few days and nights, to address these questions and concerns. This was not only about responding to criticism, but also about strengthening the legal and political sustainability of the framework. I know that question will come, the question of a future challenge. Probably this way, framework will go to court, but you have to understand that as a responsible institution, we would adopt a framework only if we have sufficient assurance that we can defend it, and defend it against, including against, in particular against the background of the criteria laid out in the Schrems ruling. So what are the core elements of the final package, and what do they tell us about adequacy decision in general? So let's first go back to the Schrems ruling. What is the court telling us essentially in the Schrems ruling? And again, this is important because the key message of the court, the ones that go beyond the specifics of the EU-US data flows, are now codified, incorporated in the regulation. So the court is telling us basically, yes, Commission, you can adopt adequacy decision, you can even adopt sectoral, so to say, adequacy decision that apply only to a region, a specific group of companies, a specific economic sector. This is recognized in Article 44.5, paragraph 1 of the regulation. You can adopt such decision provided a number of conditions are met. And those conditions are essentially four. First condition, your adequacy decision, be it specific or general, has to be based on a comprehensive assessment analysis. I would say a very comprehensive assessment analysis of the foreign system in question, of all, says the court, the relevant laws, international commitments, practices of the country in question, including, and we know that was a particular important, sensitive, and complex in the privacy shield context, including rules and practices concerning public authorities and the access those public authorities may have to data transfer for commercial purposes, access that can be, of course, carried out for all sorts of legitimate purposes, national security, certainly, but also law enforcement and other public interest purposes. Again, this need to carry out such a broad, comprehensive assessment is laid down in Article 45.2 of GDPR and is reflected in different aspects of the privacy shield. First, and that's not a detail, the length, the detailed nature of the adequacy decision. If you compare the 3 pages of the safe harbor to the 50 pages of the draft adequacy decision, plus I think almost 100 pages of annexes, that shows you the in-depth nature of the assessment we now have to carry out. Let's not forget that one of the reasons why the safe harbor was quashed was precisely the lack of reasoning of the Commission in its safe harbor decision.